opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who've also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Detrell Wembley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
And we are back, y'all. Go ahead and hit that like button as we get into Yak Gotti's bond hearing today. What you are going to notice is that things did not go as planned, as Yak ran into some additional, he learned of some additional legal problems that he has, and he was not released from jail. In order for you to understand everything, watch this entire video. Don't forget to hit the like. Don't forget to comment and subscribe. Without further ado, y'all, let's go ahead and get right into it.
All right. Ms. Rivers, are you ready?
Yes.
Okay. This is 24 SC 004460 and 23 SC 188186. Both of these are State versus Kendrick. Hello, Mr. Kendrick.
How are you doing?
I'm all right. How are you doing? I bet you could if you wanted to. I'm Judge McBurney, and we are going to work through bond in your 2 cases. You've got one case that's assigned to me in which you're charged with aggravated battery, aggravated assault, and riot. You've got a whole bunch of co-defendants in that case. And you have an older case that is assigned to Judge Whitaker, in which you are charged with having an iPhone and AirPods while you were in the county jail. Ms. Bumpus represents you. Ms. Bumpus, are you representing Mr. Kendrick for bond only or through the duration of these 2 cases?
Through the duration, Your Honor.
Excellent. So Ms. Bumpus is here for the whole ride, and then Mr. Rao is representing the state. But like I said, all we're doing today is talking about bond. So I'm going to turn it over to Ms. Bumpus. Hear from her about why you're a good candidate for bond in these 2 cases and what that bond should look like. And then I'll hear from Mr. Rao, and then you'll hear from me when you're ready.
Good morning, Your Honor.
Good morning.
And if you don't mind, I'm going to condense both the cases into one argument.
That's fine.
Okay. I'm just going to keep it short and sweet. As this honorable court, I'm pretty sure it knows, Mr. Kendrick has been in custody since May 9th, 2022. He has since been found not guilty on the charges that initially had him in custody. During those 2.5 years, he picked up these additional jail cases. The first case was picked up, as you stated, in April of 2023, the second in June of 2024. It is my understanding that Mr. Kendrick has 3 previous felony convictions, none of them being violent convictions. That is my understanding. And as we know, that is one of the factors in this court considering the bond. The second factor I'd like to address, which is extremely important to me, is community ties. And this is important to me as an attorney because Mr. Kendrick has family support. He has a lot of support. And not only are they here today, but they have been in court with him almost every day for the past 2.5 years. And I think that shows that he has a support system standing behind him. And he has a lot of accountability and responsibility to do the right thing if he's given the opportunity to be given a bond. This is a jail incident, Your Honor, and I come before you a lot, and it's very sad to say, but normally when I pick up a client who I can't get a bond for immediately, that's a double client because they're gonna get a jail case. It's almost inevitable, and especially when you have been sitting in jail for 2.5 years for something that you essentially are found not guilty for. And had he not been there, this would not have happened. He has no reason, I don't even think he has an ability to contact the victim in this case if he is granted the opportunity to be given a bond. Also, I would like to talk about the aggravated assault, aggravated battery, and riot charges. I did not represent Mr. Kendrick, and he did not have an opportunity to sit in the preliminary hearing on this case, but there was a preliminary hearing held on this case.
When you say he wasn't able to sit in, he was in through Zoom, or?
No, he was in trial, but the co-defendants were.
Okay, so there was a prelim, not as to him personally and directly, because he was in 1C.
Yes, Judge.
But in 2B, one floor up, they went forward with some or most of the other defendants.
Yes, Judge.
Okay.
And in that case, it's my understanding that the judge decided that there was the facts did not arise to an aggravated assault, but a battery. And I know that, you know, the state can then go and indict it and do what they do, but I just wanted the court to know that. In the bond motion that I filed, I specifically stated the DOJ report that was issued in November of 2024. This is extremely concerning for me because my client knows this all too well, because he was actually a victim of a stabbing on December 1st. And you are very familiar with how it goes when people are close to release and when people are in high profile cases, and there is a target on his back. And, you know, I'm not sure, but there are also some people who may not be very happy with the not guilty verdict in this case and what he has alleged to have been a part of, but found not guilty of. I don't believe Mr. Kendrick has any history of FTAs. I have watched him fight for his life for 2.5 years, and I can only imagine the resources it took to afford an attorney, to afford clothes, to afford everything that he had to do, but he still found a way to afford me, which means he takes this case serious, even though it's a jail case, which means me and him are gonna work together to make sure he's back at every court date and do what we have to do so that he can follow any conditions given by this court. Considering the fact of everything, I'm asking the court to set a bond no higher than $20,000 on all the counts.
Talk to me about where Mr. Kendrick would stay. I don't mean a specific address, but with whom, what that setting would be, and what kind of work he would be able to do if he's going to be working when he gets out. And I know some of those are strange questions because he's been in for 2.5 years. So it's not like there's a job at this firm where he was working for, hey, we held your spot for 2.5 years. But I trust you and he have discussed something about the structure that would be in place. And that would help me understand what Mr. Kendrick would be up to and not up to should he be released.
Your Honor, Mr. Kendrick was a recording artist and is a recording artist, and not just, you know, our typical, you know, I'm a rapper, but a real one. And as soon as he's released, I believe he's going to start back making music. And before this, I have pictures ready to present if the court wants to see, but I'm an officer of the court. But he was coaching Little League, he was performing, he was being a valuable member of society until arrested for charges that he was found not guilty of 2 years later, as he sat in the Fulton County Jail. I do have an address, and I did speak with his mother this morning that I can provide off the record.
Sure.
And it is a complicated situation because he's been in custody, but they have been working hard since I filed this motion to find somewhere for him to go.
He would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk about off the record just because of the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise for Mr. Kendrick, while he's on bond for these 2 cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot, it's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation to say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. And so that's the only reason why I'm asking. It's not for you to share publicly. It'll be 123 Main Street, and he'll be staying with this person. But those people need to not be people with whom he associated before, not because that's necessarily a forever condition, But if he is going to be on bond for these things, I think everyone needs a comfort level, and basically for his own safety. You're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that we need to have some email back and forth about what those conditions would look like, who can be around Mr. Kendrick, who he needs to not be around. And something as simple as you can't go to those studios, because those studios are ones where we read about them and it's a great music making place. And the next day there's a dead guy in the parking lot. And it has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're gonna be working on getting a studio in wherever he resides so that he can, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay. All right. I don't want to get ahead of it. Maybe that bond's not appropriate, but I wanted you to know that if I do set a bond, we may need to have some exchanges, including the state, about, well, what's that going to look like structurally, so that I know what I can put in the bond that's not sealed, because there'll be a bond order that says, here you go, but there may be certain things that are under seal for a good reason. So we can work through that. But your request is a $20,000 bond across the 2 cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me see. I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties, but could you pop your mic on and say hi?
Hi, can you hear me, Your Honor?
Okay, yeah, it didn't work again. It's not on your end. It's something happening here, because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great. And I'll look in what's in the chat. Oh, okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation and then I'll get the warrant out to everyone.
Yes, Judge. The defendant stands before you, having been indicted on 2 separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who've also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Detrell Wembley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's co-defendant, Thomas's lawyers, is that not all, and they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case.
Okay.
Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire time. And by he, I mean the victim. The victim
Okay.
remained there.
Got it. Let me pause you for 1 second. IT thinks they fixed the situation. Let's try Officer Evans. Officer Evans, can you?
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Ms.
Yes, Your
Hansberry. All right. Somehow that device's volume got turned down, but we're back. All right. So your view from a review, your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault. I'm going to call it the assault case.
That's correct. And in addition to that, the sheriff's office had an opportunity to speak with Mr. Kendrick. And essentially there's a lot of commotion in the background because it's on a body camera footage. But they were able to secure a statement from Mr. Kendrick and
Mr. Kendrick or from Mr. Wimberly?
Both, but
Okay. With
respect to Mr. Kendrick, it's essentially saying, what else am I going to do? It's about respect. They're stealing my stuff. I got to do something. So I would disagree with the assertions that this is just a battery. And I think I'm more than happy to share the photographs with the court, and then the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does in fact have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC, for which he was sentenced on February 22nd, 2017. And I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation. Then on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation of criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in a vehicle, where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case.
Can you give me that case number again, please?
Yes, Your Honor. 15 SC 140116. And it does appear that he is on active probation for that particular case, having been sentenced to a 15 years to serve 2 sentence, with the balance of the first 8 years on probation, with the remaining last 5 years being suspended. In addition to that, Judge, we believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022 and this date, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents, 10 are allegations of violence and 3 are allegations of possession of contraband. And those include the indicted cases before the court today, which the defense is seeking a bond hearing. And many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth in this particular case. And every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assaults. And so while I certainly understand everyone is talking about the conditions of the jail. Exhibit A is before you as to why it's unsafe. So, Judge, we're respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk to reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
Do you have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for a management, frankly. I mean, just Bumpus needs to know what she and her client are up against. And I know that your office exercises discretion and doesn't indict every little scuffle that happens at the jail. Is it safe to assume that your office has filtered through that and we've got the two cases, the contraband and the assault? Or what's your sense? I know you're not committing the office, you're not in that unit, but you do have some managerial perspective.
From my understanding, Judge, there is one unindicted case that's been brought to our office. So I'm going to take a look at that and make a determination. With respect to the other ones, without committing anything to the court, I don't believe we'll be going forward on any of those.
Okay, so they would be at most, if Mr. Kendrick would go to trial, could be 404B or could be linked to one of these other situations. Or it would be something in aggravation at a bond hearing or at a sentencing hearing.
That's
Is your
correct.
best forecast with maybe one exception.
That's correct.
Okay, all right.
Thank you, Judge.
Thank you. Ms. Bumpus, want to give you the last word. I'm gonna not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. And certainly want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that because the last time that my client committed a crime was in 2015, 10 years ago. And well, minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but that doesn't mean it wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case. So they're not two separate crimes.
Okay.
This 2015 is the federal case.
All right. So there just was dual sovereigns and Mr. Kendrick got squeezed in both places.
Yes, Judge. So not two separate acts.
Okay.
And me saying that, I don't know if this brings any or can help us get clarity on the warrant because my client's understanding is that the federal probation then trumped the state probation and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. There's supervised release. That's what they call it on the federal side. And it may well be that Mr. Kendrick had a very clear understanding with DCS, state probation. Hey, you report to those federal folks. But that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these two cases. So as is par for poor Mr. Kendrick, everything's all connected. And so it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband and was allegedly part of the assault of Mr. Wimberly. And you know that's how it flows. And so if that warrant is out there, then we need to work through that and setting a bond doesn't make a lot of sense until that warrant is addressed. You know full well, once that warrant is addressed or if it's lifted or it's dismissed or I don't know that judges tend to set bond on probation warrants, but if so, then we don't need to reconvene this session. I'll know that warrant's out of the way. And then it does make sense to think about what a bond would look like for Mr. Kendrick for the two cases for which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter or is this our universe, the assault case and the contraband case?
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those two, the federal case and the state case, are one occurrence.
I got it.
And that the additional alleged acts in the jail, I mean, he has not been charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's going to do, don't do it piecemeal 3 months later, and then 3 months later, and then 3 months later for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff and you need to decide what you're going to deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back. It's like, all right, and this time it was a cell phone. This time it was a cheeseburger. Let's just wrap it all up if that's what's going to happen. And I trust Mr. Rao is going to look into that. And they typically don't get every cheeseburger case. You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. And they said, well, not so much. He was a saint who ate cheeseburgers. Okay. And we worry whether that's a big deal or not. The big deal right now is the possibility that there's this warrant, which makes bond moot in these 2 cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015 because it would be that state probation. Okay. Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure good lawyer, she's going to explain it all to you, but there's a chance right now, not about the facts of your case. Don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
I pretty much understand everything.
Okay. All right. Well, Ms. Bumpus will explain whatever you don't. And we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these 2 cases for now. If there's not a warrant or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured. So I can see if I'm comfortable that there's a set of conditions that would keep Mr. Kendrick safe and also keep him out of the kinds of things that he needs to stay out of until he resolves these 2 cases.
And Your Honor, how am I gonna, can someone email me about the probation? Or?
I will keep everyone in the loop.
Okay, thank you, Judge.
All right, Mr. Rao, anything else from the state?
Yeah.
All right, for those of you who were here for Mr. Kendrick, thank you for being here. I'm sorry you had to give up your phone. You'll get it back when you leave.
And Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Thank you for being here.